Hello everyone, welcome back to Believers Academy Bengaluru. This is topic of the day session. In today's topic, we will be discussing a very important and burning issue, that is intellectual property rights and generative AI, which is significant from paper 3, 2 and ethics as well as essay. So context is two landmark rulings in the US on June 24 in lawsuits involving Anthropic or the Claude AI and LLaMA models mark the first major judicial interpretations of whether training AI models on copyrighted content constitutes fair use or copyright infringement. A highly heavy loaded or value loaded context. So the context here is simple. There are large language models such as ChatGPT, Meta's Lambda, and Claude. They are actually trained on certain data sets. So that they can generate content based on the data which is already fielded in them. They generate content. This is called as generative AI. Okay, now how they are trained? They are trained on particular data set. The now current case is that according to the lawsuit filed against this Claude and LLaMA, they say that the data on which these large language models were trained is taken from a pirated content or pirated site, which means the big tech giant companies like Meta and Claude are involving in pirated site content. So they are involved in piracy. So that is the case, that they are involved in piracy. However, the court said that it is not piracy, it comes under fair use. Okay, we will discuss in detail about this one. This is the basic actually. So the key judgments are two. One is Anthropic case, that is Bart's and other versus Anthropic. Anthropic is the parent company of Claude AI. Allegation is it used pirated content, that is from Books S3 shadow library to train Claude model. Ruling is Judge Alsop ruled that AI's use of data was transformative and thus it comes under fair use. They say that though they might be trained from pirated content, their outcome is transformative in nature. They are not just giving out the content which is already taken from the pirated, they are improving upon it, they are transforming upon it. As a result, it is transformative and it comes under fair use. So AI does not replicate but generates new content. However, the pirated book storage is infringement. That is trial to determine damages in December 2024. However, they acknowledge that the pirated book storage is infringement. So whatever the money that has been lost to the original content creators, that has to be supplemented or complemented by either the Book S3 or Anthropic. That will be decided later. Then is the Meta case, or Silverman and others versus Meta. Allegation is LLaMA was trained on Book S3, LibGen and Anna's archive. All are pirated. Meta's defense that it applied mitigations to prevent reproduction of copyrighted content. The ruling is that no proof of market harm and AI's response is not similar to the original content and there is no infringement proved. However, court acknowledged ethical and legal gray areas and called for greater compensation. Okay, we agree that you might be not giving out whatever you learned from the archives or whatever you learned from the pirated sites as it is, you are improving upon it and you are generating content that might come under generative AI, that might come under transformative, or it might come under fair use. However, there are losses incurred to the original author or the original content creators who have been pirated by Book S3 and this. So you have to compensate them. In both cases, the court said it is a fair use. However, there are ethical considerations that you have to compensate for the original content creators. Then the legal concepts involved is mainly three are there, that is fair use, Fair is purely legal in nature. Legal doctrine allowing limited use of copyrighted material without permission for purposes such as criticism, research, and education. And transformative use, when a new work adds new meaning, message, or utility, it may be considered as transformative and qualify as fair use. That is the case with respect to Claude AI now. Then, in market dilution, if a new work negatively impacts the market of the original, example, free AI biography competing with an author's book, infringement is more likely considered. Meaning, if the utilization of a particular content by artificial intelligence is going to affect the market of the original author, then it means there is infringement on the ground of market dilution. Okay, you are taking away the profit from the original content writer and you are writing a summary or biography of a particular individual through your AI, which is obviously market diluting. Then global and Indian implications. In global impacts, it sets precedent for AI copyright law. Though not final, most cases still are in early stages. May influence pending lawsuits against OpenAI, Microsoft, Stability AI, and Getty Images. They are all going through the same kind of issue. Calls for industry-wise licensing mechanisms similar to how music streaming pays royalties. Okay, so what happens in music like streamings? For example, there is Spotify. So in the Spotify, all the famous singers' songs are listed. For example, take the case of Eminem. So Eminem is a famous rapper and his songs are listened to billion times by people. Those billion songs or billion times is listened on the Spotify. The revenue is going to Spotify. So Spotify is enjoying out of the songs of Eminem. So now what the Spotify should do? Whatever the income they are generating, whatever the profit they are getting, they have to provide certain royalty to the original content creator. That is Eminem. Similar can be the case with respect to AI as well. Then India specific concerns. In India also this case have been taken up. For example, recently there was an issue with Ani and OpenAI. Ani is a news laundry in India. So India's first major copyright lawsuit on AI training. And there is a Digital New Publishers Association, that is DNPA, which is representing Indian Express, Hindustan Times, NDTV, has joined the complaint along with ANI. They say that India lacks specific regulation on AI training data, making it vulnerable to content exploitation. Their complaint was that whenever you search a particular content on ChatGPT, ChatGPT searches the global web, and it searches the global web and provides certain content on a particular topic, and it also provides sources of this content. For example, if it is taken from Indian Express, it is provided the sources. But the complaint of these news launchers or the media houses is that they are using our content and they are only providing the link to our content, but they are not resulting in the revenue generation to us. The ChatGPT is diluting our market share here. That is the case here. Next, key data points are there are 21 plus lawsuits ongoing in US over AI training. AI tools like ChatGPT are trained on hundreds of billions of tokens, including books, articles, and codes. Book S3 dataset, which was used in Anthropic and Meta, contains 7 million plus pirated books. Okay, so it is legally maybe not wrong, but ethically it is very wrong. So ethical implications. One is loss of livelihoods. Writers, artists, and coders may see reduced opportunities due to the generative AI outputs. Initially, what used to happen was the writers, whatever the book they used to write, it used to be published by media houses or it used to be published by Amazon, Kindle, etc., on the digital platforms, and they used to get certain amount of money based on the profits. Now what happens here is the books are pirated and the artificial intelligence is generating the content out of it, and this is resulting in the loss of livelihoods for artists, artisans, writers, etc. And also there is an issue with creative ownership. That is, AI generates derivative work, but who owns it? The model the developer or the creator of training data? This question needs to be addressed. And with respect to transparency, tech companies often do not disclose training data sources, undermining the accountability. These things have to be addressed. Okay? Then, so what should be the way forward? First is addressing AI and copyright law reform. Frame clear IPR guidelines for AI training data, require transparency in training sources used by AI models, and create compensation framework. That is, create content licensing platforms for AI companies as with the music royalties. Also, fund a Creative Commons for AI where creators choose terms for AI training use. If you are going to train your AI based on our content, there are certain terms and conditions which you have to adhere to, such as royalties, compensation, etc. etc. Then, with respect to digital infrastructure, build secure digital rights management systems to protect Indian content. Use blockchain to track content usage and attribution. And finally, collaboration and global advocacy. Should work with WIPO, OECD, and UNESCO to develop a global ethical framework and push for AI copyright treaties under the international law. Because if one country is bringing artificial intelligence law and a person sitting in another country is violating that law, defeats the very purpose of the AI law. So the AI law should be in collaboration with multiple global leaders. Only then we can address the issue of AI and copyright. So this is a very interesting topic and a burning topic. In conclusion, there is no conclusion for this. Okay, this is a very important topic. So if you like the video, then please hit the like button, comment on it, and also share with your friends. And if you are new to the channel, please subscribe to the channel and click on the bell icon so that you don't miss any notification. With this, I will end the video. Jai Hind.